David Fowler here, and I'm going to be doing a couple of videos for those of our constituency that are interested in the pro-life issue and want to understand what's been taking place the last 2 weeks or so in particular regarding the abortion legislation the General Assembly passed this past spring. It's the governor's proposal. In future video, I'll explain the two parts of the law, but let me give you a couple of just concepts that will help you understand the next video a little better. There are a couple of things that takes place when a lawsuit is filed in a situation like this. The first thing is that often the plaintiffs will challenge the law as being unconstitutional on its face. It's called a facial challenge. It simply means that there's no set of circumstances under which the law could be found valid or constitutional. Let's put it that way. The second is an as-applied challenge, which means that the law on its face would appear to be okay, but when it's applied to particular persons under particular circumstances, then it's not. That's an applied challenge. So what is taking place right now in the court is a challenge that's facial. There's no set of circumstances under which any part of the law could be valid. Okay? The second thing you need to appreciate is just what is an injunction, and there are a couple of different terms of art you'll hear: temporary restraining orders and preliminary injunctions. A temporary restraining order is simply an order that keeps the party being sued, in this case the state, from doing something, or in this case enforcing the law, until the court can have a preliminary hearing, which is a hearing prior to the full trial when all the witnesses would come in, to decide whether or not to prevent the law from going into force while the case is being tried. So here's what happens. You ask for a temporary restraining order. Oftentimes there's no hearing on it. The judge looks at what's been presented with the complaint, maybe a few affidavits, and says, okay, I'm gonna keep the state from enforcing this law, but we're gonna have in a few days a preliminary injunction hearing, and then you can bring in more testimony. I'll hear it, and then I'll decide whether to preliminarily enjoin the law before deciding whether to finally enjoin enforcement of the law at the end of the trial. So those are the kinds of procedures that are taking place. Now let me just explain quickly what happened. The federal district court enjoined both parts of the law. There are two parts to this law. The first part is the gestational or timing ban provision. It says that a doctor cannot perform an abortion beginning at a heartbeat. If that's not constitutional, then at 8 weeks, and at 10 weeks, and so on and so forth, up to 24 weeks. The other part of the law simply says you can't perform an abortion if you're a doctor if the reason for the abortion is because of the child's sex, race, or ethnicity, or a diagnosis of Down syndrome. So those are two parts of the law. What's going on in the court right now is that the whole law was temporarily restrained. Then the judge had a preliminary hearing and preliminarily enjoined the whole law. The state appealed the preliminary injunction as to the whole law that went up to the Sixth Circuit. They appealed it on a facial challenge, saying you can't say the law is facially invalid, that there are no circumstances under which either part of the law cannot be constitutional. So the Sixth Circuit has that still sitting in front of it. Now what the state then did is they appealed the preliminary injunction as to the reasons ban, the discrimination ban, the idea that you can't perform an abortion because of sex, race, ethnicity, or Down syndrome. And they said that law is clearly should not be restrained while we proceed to trial on the whole law. Now, the district court held that the reasons or discrimination ban was unconstitutional because it was too vague. The doctor didn't know what he could or could not do, and for what would be a crime or what wouldn't be a crime. And so the state said that's just not true. To the Sixth Circuit, that's what they said. The Sixth Circuit said, we agree, the law is not unconstitutionally vague. The state's correct. So the Sixth Circuit, about 2 weeks ago, sent the case back to the district court, said that reason for not letting the state enforce the reasons ban is not legitimate. So the district court was then faced with the question, okay, so the law is not unconstitutionally vague, but does it violate the standards in Roe versus Wade and Planned Parenthood versus Casey, which says you cannot impose an undue burden on a woman's liberty interest in making an abortion decision? What the court said in that case was, no, the law does not unconstitutionally burden the woman's right to make an abortion decision on its face. I'm not willing to enjoin it on that ground, restrain it on that ground, and then set the case for a hearing December 7th on a preliminary injunction to decide if that temporary decision to allow the law to go into effect should continue. I hope that makes sense. So what the plaintiffs had asked for on the reasons ban was, would you temporarily restrain the ban? The court said yes. And then they said, now will you preliminarily restrain or enjoin the enforcement of the reasons ban? The court said yes. Now the court, after the Sixth Circuit ruling, has come back and said, upon reconsideration, I don't know that the law is unconstitutional, and so I'm going to deny Planned Parenthood's motion for a temporary restraining order. But they're still entitled to have a hearing for a preliminary injunction, and so that's the hearing they're going to have on December 7th. And the court, hopefully, will continue to believe what he believed earlier, that the reasons ban, the non-discrimination ban, is not an undue burden on a woman's right to make an abortion decision. And the state's interest is legitimate in preventing that kind of abortion. So that's the hearing that'll be up on December 7th, and I look forward to talking with you more about these cases.